on time. We really appreciate. So we'll be able to begin in the next 1 minute. So we give ourselves 1 minute, and then now we'll be able to kick off. Okay, thank you once again. And as I've indicated, I'm Raymond Molenche. I work for Kenya Bankers Association. I head the legal, HR, and policy advocacy function within the association. And on this journey, I know it's not the first time. It's actually just a continuation of keeping on empowering ourselves within our various spaces of businesses at whatever level that we are in. So as KBA and as we've been on this journey, we are glad to ensure that, yes, we keep working together, empowering each other, and also sharing information and knowledge, and having this platform to just be able to bring to you experts from different kinds of fields who will be able to empower us to ensure that, yes, we, as we begin our businesses, as we grow our businesses, we can actually be able to ensure that, yes, we are complying to all the legal requirements that are there. And also we are getting new ideas to be able to advance and be able to ensure that, yes, we don't remain where we are, but we push on. Now, before we get into the discussions with our experts, for just 30 seconds, I'll request our two experts, Beatrice Osicho, who is the Deputy Official Receiver at the Business Registration Service, which is the mother of all of us. So I will not touch anything on the Business Registration Service. We have the owners in the house, so they'll be able to explain to us further. So there's Beatrice, and then there's Zachary Mwangi. So I'll just request Beatrice and Zachary Mwangi for 30 seconds to just be able to say hi. They'll be able to introduce themselves further as they begin their discussions. So we'll begin with Beatrice, just 30 seconds, and then also Zachary. Thanks for putting on the video. You'll also just introduce yourself for 30 seconds, and then now we get back to Beatrice to be able to begin the conversation on what is business registration service, how do we as businesses get into it, and what have you prepared for today for our discussions. So Beatrice, over to you.
Thank you so much, Raymond. Hello, everyone. As Raymond just said, my name is Beatrice Osicho. I work at the Business Registration Service, which is a semi-autonomous government body or parastatal, which I'll delve into right after Zachary introduces himself. I'm a Deputy Official Receiver in the Official Receiver Department. I was previously a state counsel before BRS became a fully fledged parastatal. I'm very happy to be here, and I hope we'll have an active engagement. Thank you. Zachary?
I'm Assistant Registrar of Companies, stationed at the Business Registration Service. So we shall interact more as I present on the business, on the beneficial ownership information, which shall come after we give you an overview of the Business Registration Service. So welcome to the webinar.
Yeah, thank you so much, Beatrice and Zachary. And just one point is that as we get in the discussions, please use the chat to be able to raise your comments, to be able to raise your concerns. And then now at the tail end, we'll be able to get back and be able to provide feedback, which we'll be able to ask our experts to be able to explain further on those comments there. So please use the chat to be able to put your comments, put questions, put concerns. Thank you so much. Over to you, Beatrice. Thank you.
Thank you again, Raymond. Once again, everyone, welcome to this session. Plan this session is just to first introduce what the business registration service is. Most people do not know exactly what we do or who we are, and that is the purpose of why we're here. Then once I am done with that, we will, Zachary briefly just take you through what has brought us here. And I do know there's been a bit of talk and whispers on beneficial ownership. And I believe Zachary will give you a much more direct information with regard to what is the beneficial ownership register and the purpose for that register for everyone's information and the requirements that you're supposed to give. Once Zachary is done, I will then take you through aspects of what we do, which is the Movable Property Security Rights Register, and that touches on secured transactions and insolvency, which I believe is important, knowing that this is a forum on small businesses. So just to kick us off, the Business Registration Service is a semi-autonomous body under the Office of the Attorney General and Department of Justice. We became a parastatal back in 2015 when the President assented to the Business Registration Service Act. We oversee operations of the company's registry, the insolvency department, also known as the official receiver, and the Movable Property Security Rights Registry, which is also known as the Equilateral Registry. We also administer all the laws relating to those particular registries. We carry out registrations that are required under the BRS Act. And once again, I'll reiterate, under the company's registry, the registrations with regard to opening of businesses, be it a sole proprietorship or a limited liability company or a public company. We also register companies limited by guarantee. We also register limited liability partnerships and partnerships in general. So anything that is a business entity falls under the mandate of the company's registry, which is under the Business Registration Service. We also administer the another registry, the Equilateral Registry, which I'll talk about again on all security rights and interests that are established of a movable collateral. We not only maintain those registers, but we also maintain all the data and records on those registrations that are carried out. We also implement relevant policies in relation to those particular registries and the insolvency registry. Forgot we also administer the hire purchase registry, and that is limited in as far as hire purchase company registrations are concerned. The hire purchase agreements are not registered with us anymore. We'll talk about that under the MPSR Act. Again, we implement relevant policies with regard to our mandate, which is Act, Insolvency Act, Hire Purchase Act, and the Movable Property Security Rights Act. So another one of our other duties is to undertake research and disseminate findings through seminars, workshops, which are doing here, publications or other media, and we recommend to government any improvements in the relevant laws. Again, this is something I believe KAB has been a part of. When we started with the Chattel's Mortgage and shifted through the Movable Property Security Rights Act, we advised and initiated policy review on secure transactions. When we moved from the BRS, Bankruptcy and Companies Act to the Insolvency Act, again, we drove that policy review so that you could have the Insolvency Act, the same with the Companies Act from CAP 486 to the Companies Act of 2015. We also collaborate with different state agencies for effective discharge of our duties. Again, we'll basically touch on this or you'll hear discussions on this during the duration of this webinar. Of course, we charge fees for our services, and we also carry out any other functions that may be necessary under our laws. And with those very, very few and a very brief introduction into BRS, Zachary, maybe you can take over. Zachary works for the company's registry, which mainly deals with the register of beneficial owners. So Zachary, over to you. Thank you.
I think before we go on, I can see we have counsel from the company's registry who have joined us. We have Karen Dego with us. We have Anne Kanake, and we also have Sarah Inaina. They are registrars at the company's registry. But I'm not sure whether we have enough time to introduce each and everyone, but I think we can get right to the presentation. So I'll be taking you through beneficial ownership information. We understand this is an issue that has generated quite some heat, but we believe that we only need to understand what we seek to cure by introducing the requirement of beneficial ownership information, such that every company is required now to at least register this information. So let's start from the beginning. So as you can see from the background of the page or the introductory page, there lies all our problems. As you can see, there's a figure there, which is faceless. And that is exactly what you're trying to cure, that we have companies which have been registered, but you cannot exactly tell who are behind these companies. And why do we need to know who are behind the companies? The main reason is that we need to curb a few illicit activities, such as money laundering and terrorism financing. So as you're going to see across the presentation, those are the main cross-cutting issues that we are trying to curb. And maybe Raymond can also explain that in the recent years, they've been trying to curb this through various reporting requirements by FRC and maybe asset recovery, all those issues. And on our end, what we're trying to do is to ensure that if investigative bodies come calling, we are able to pinpoint as to who is controlling these particular registered organizations. So the background. So we find that in the year 2010, Kenya was listed in a list called the Grey List. This is a list that is kept by the Financial Action Task Force. The Financial Action Task Force is an international organization that is tasked with providing mechanisms to curb money laundering and other illicit activities such as terrorism financing. So they come up with proposals or mechanisms which can be used to fight such kind of activities. And part of their proposals was that we need to come up with laws that are going to help us fight those two issues. And Kenya eventually did, and it was removed from that register from that list in 2014. Now, what remained is that we did not have a mechanism now of finding out who are behind various registered organizations. As you can see, these are the issues of concern. We do not have transparency in the terms of who owns some of these registered businesses. For example, if you look at the setting of a company, we usually say that it is a separate legal entity, meaning that it is separate from those who have established it, such that if you're trying to transact with the company, the only thing that you're going to see is the name of the company and maybe the directors, but you're not able to go behind and see who are actually the owners of the company. So one of the issues that we have is transparency, that we do not have it. Then we have some situations where we have nominees. These are people who lend you a name to use. For example, I am the actual owner of a certain company, but it is registered in the name of Beatrice. So if you're going to scroll back into the registry of companies of that company, you're going to find Beatrice's name. But in the real sense, she is not the registered owner of that company. I am. So such kind of issues. And then you have an aspect called bearer shares. This is a situation where we can equate it to maybe, for example, we can say bearer checks, where you do not need to list the name of the person who is holding that particular share. And that's a problem, because you can have maybe a company that is owned 60% by individuals who are not known because they hold the bearer shares. Then we have shell corporations. This is a situation where you have layers and layers of companies. And if you try to look for the individual behind all these companies, you'll be running in circles. You'll not get the individual. So those are some of the issues of concern which has led to the requirement that we must have beneficial ownership information disclosed. So next. As you can see from that illustration, this is an individual who has received a call that the wife and kids have been kidnapped and he's been asked for ransom. And his main concern is he's saying, thank God, he did not get my UK interest. So it is more easy for this person to disclose or to disclose any other information, but disclose information relating to the companies they actually own. And that is a big problem. So the objective, as I had stated earlier, we need to prevent legal entities from being used by individuals for money laundering and terrorism financing or any other illegal activities. So that is the main concern. That is the main issue as to why we have beneficial ownership information being disclosed at the moment. Now, we'll begin with a quote from Fred Matiang'i, as you can see from the presentation, where he listed a number of individuals who are financing terrorism. And the main reason why he says he disclosed that list is because he needed to choke these people so that at least anymore. So we also believe, at least to investigative bodies, then we are able to ensure that they are not. So I was trying to explain who is a beneficial owner. And as you can see from the screen, it's a natural person who either controls companies, foundations, limited liability partnerships, or any other legal arrangement. When we're talking about a legal arrangement, we can talk about, for example, a trust. That would be a legal arrangement, or any other arrangement which is not registrable under the business registration service. Now, how do you identify a beneficial owner? We say that a beneficial owner, for the purposes of at least of the company, or a person who has, whether this is directly or indirectly. Then if you have the right to appoint or remove a director, then you can be disclosed as a beneficial owner. We also have other people who have influence in the company, not necessarily in terms of voting rights or shareholding. And you can see from this illustration, maybe you have the ability to veto some of the decisions made by the company, or maybe you hold some form of privileges that are given to you, maybe because you've advanced some form of loan to the company or any other form of arrangement. So those are the people who we require that they should be disclosed by the company. So who should disclose and when? According to our Companies Act, which introduced the beneficial ownership information requirement, every person or every company is required to keep at least the register of beneficial owners. Once that register is prepared, they're supposed to register the same with the registrar within 30 days after its preparation. If there are any subsequent amendments, because you can see once in a while, company changes hands and beneficial owners change once in a while, so you'll be required to provide that information within 14 days. But this requirement is not there for public companies, such that if the information is to change, you'll not be required to provide that information within 14 days if you are a public company. Now, we have set a deadline for compliance for this, that is 31st July 2021. If you remember, we had an initial deadline of 31st January 2021, but we realized that most companies had not complied. So the same was extended to 31st July 2021. So companies by then will have been required to disclose, and then if you fail to disclose, we shall speak of the repercussions later on. So this is the information that will be required from you if you are a beneficial owner. You require your name, your ID, KRA PIN, your nationality, and the list goes on and on. You'll also be required to disclose the date in which you became a beneficial owner of that particular company. Now, what are the steps that the company can make maybe to try and identify the beneficial owners? The first step is to write at least to every person the company believes is a beneficial owner. And you would be writing to them, asking them to give you the information that you just scrolled on. This information is the information that you'll be asking them to provide you with. Once you receive that information as a company, you prepare your own register of beneficial owners. Once it is ready, within 30 days, submit the same and lodge it to the company registry. Now, if you do not receive any information from the person whom you've requested to give you the information, there is another warning that you're supposed to issue. And that warning notice is supposed to tell the person that if you do not comply within a specific deadline, then we shall restrict all your interest in that company, such that if you had voting rights, then you'll not be able to vote. If you had shares, you'll not be able to transfer those shares. If you're entitled to any dividend, you'll not be able to receive that dividend until that restriction is removed. And that restriction will only be removed if you comply. So those are the repercussions both to the company and to the individual. As you can see, for the company, we have a fine of 500,000 if you do not comply.
Hi, Zachary. Is that on a slide? You can be able to present again because you dropped at some point.
Pardon?
Pardon? I'm saying the slide that you are referring to.
In terms of?
Are you presenting some slide?
Yes, there is a slide. You're not able to see it?
It dropped at some point, so we thought you had finished the slides. So if it's still on slide, you can share again, because it's key for us to see the fines provisions there.
Okay. Let me share again. I think I received a call in the middle of the presentation, so that's how it dropped.
Oh, it dropped. Okay.
Yeah. So sorry.
Okay.
You're able to see now?
Yes, it's visible now. Thank you.
Okay. So I don't know where I dropped off, but I think most of the information in the presentations, in the slides, I have already shared. So maybe I'll just take you through the remaining parts of the presentation.
Yeah, you'll just continue because I believe you'll share with us the slides after. So yes, you can be able to share with all the participants again. Yeah, thank you. Okay. So I can just proceed. Thank you.
All right. So I was here, and this is what I was talking about. If you do not disclose the information as an individual, you'll not be able to transact with, for example, if you have any shares in that company, you'll not be able to dispose them. That is, you'll not be able to transfer them. You'll not be able to exercise any voting rights or any other rights that you may have in that company. And if you're entitled to any form of payment, that is in case of a dividend, you'll not be able to receive it until that restriction is removed. So once you comply, once you provide the information that is required by the company, then that restriction will be removed. And then you'll be able to maybe enjoy the rights in that particular company. So in terms of confidentiality, this is a major issue because people have been asking what will happen if this information gets out to the public. But the guarantee that you are issuing is that this is a private register. That means that it is only held by the company and the registrar. Nobody else is supposed to have a sneak into the register of beneficial owners. Now, this information is not supposed to be used for any other purpose, even by the company and the registrar. It is only supposed to be used for the purposes of communicating with that beneficial owner. Now, there are circumstances where maybe an investigative body which in this case is referred to as the competent authority, may require information regarding a beneficial owner. Under such circumstances, that information may be provided, but then the authority has to provide a written request for that. Now, in the event that maybe a court has stopped the production of such kind of information, then that information will not be availed. There are other circumstances where maybe this information may be released in the event that the beneficial owner has given consent, or maybe a court has ordered that this information be disclosed. Now, if you disclose that information in any other manner, other than the ones I've listed above, then you'd have committed an offense under the Companies Act.
Apologies, Zach. There are some participants who are saying if you can increase your volume. It's clear from my end, but it seems there are some participants who, so I don't know whether your volume is maximum.
All right.
From my end, yeah, try to see whether.
Okay.
Yes.
Now, how do we file beneficial ownership information? Because we have talked about the theory aspect of it, but in terms of practical application, how do you go about filing your beneficial ownership information? You realize that most of the companies that we have, or quite a number of the companies that we have, are not linked on the eCitizen platform. That means that the first step will be to link the company first. That is not a chargeable application. Once you get access, you'll be required to file your annual returns. That is, if, as you can see the example provided there, let's say your company was registered in 2015. It means you have annual returns overdue for 2016, 2017, 2018, and 2019, and 2020. You'll have to file all those annual returns. You'll be given an avenue to provide the information. And then once it is verified, you'll be able to now lodge any other further application, such as providing the beneficial ownership information. So for the annual returns, as you can see, it is a chargeable application. And if you are late in filing it, in every year that you are late, you'll be fined 500 shillings. Now, the actual application or the actual disclosure of beneficial ownership information is done on the eCitizen platform. You log into your eCitizen account, as you can see. Then once you log in, you go to the business registration service part. You'll be required to log in again. So you log in again. Then this is the first part. If you have any company that is linked, then you will see your company will appear. As you can see the enclosure in red, your company will appear there. And the status, BO status, will be reading as pending. So from there, you'll click on the view button. Once you click on the view button, you'll be able to see this will be the dialog box from your end. And then you can click on maintain a company. As you can see the arrow pointing over there. So once you click there, it will take you to this part where you have the business details. And as you can see, we have address, share information, directors and shareholders, beneficial owners. So you'll click on beneficial owners. Then next, you will be taken to this tab where you have change of particulars. You'll click on change of officials. We understand that this is not an application for change of officials, but they're using the same queue. They're using the same, in short, we've not split the two applications, that is change of officials and change of beneficial owners. So they'll be using the same tab. Then this will appear. The list of the people who are shareholders and directors of the company will already be there, such that you'll only be required to update the information. You do not allot, you do not forfeit unless the application relates to such kind of a transaction. You do not resign them, you go to update the BO. So this is the kind of information that you'll be required to update. If, for example, you are one shareholder and director in a company, this is what will appear. Your total ownership will appear as 100%. And then you can disclose whether you are a direct owner in the next on the right part where we have direct ownership in percentage, you can disclose whether you own the whole percentage, that is 100% directly, or if you do not, then there is another section where you can have that disclosed. If you have 100% voting rights, you will disclose there. If all the 100% voting rights are direct, then you also disclose there as 100%. If you are two shareholders, most likely it would appear as 50-50. So if you go to one shareholder, this percentage appearing here will be 50%. Then for the next will be 50%. So you'll have allotted in twos, that is 50-50 in equal measure. That is if the shareholding is split in half. Then this is what will appear. This is after you've disclosed all the beneficial owners. You'll have something similar to this, indicating the names, the nature of ownership, whether it is direct or indirect, the voting rights, whether they are direct or indirect. Then you save and continue. This is what will appear next. On the left-hand side, you can see there is a download button. That is a form generated by the system, depending on how you have disclosed the information. You are required to download it, sign it, and on the right-hand side, upload it. Once you have uploaded it, save and continue, and you'll have finished the process of disclosure of beneficial owners. So during the presentation, you might have noted that there are some images in the background. As advocates, we are very cautious. That is just a disclaimer that I do not own any rights to the pictures or images appearing therein. And that is the end of the presentation. If anyone has a question, maybe you can have it in the comment section, and then we can be able to address it. Thank you. Maybe I'll welcome Beatrice to proceed with MPSR and insolvency. Thank you, Raymond.
Yeah, thank you so much, Zachary. So in the interest of time, I'll be able to allow Beatrice to proceed.
Thank you so much, Zachary. So I'll be covering bits on the Movable Property Security Rights Act and insolvency. And I'll start with the Movable Property Security Rights Act. Rosaline, if you could share your screen. Thank you. So the Movable Property Security Rights Act is an act that was assented to by the President on the 10th of May of 2017, on the 16th of May 2017 by legal notice number 77 of 2017. The key objective of this law was to facilitate the use of movable property as collateral for credit facilities and to establish an electronic collateral registry to provide for registration of interest in movable property. So, of course, this was formed by a lot of policies, and some of the policies that informed the enactment of this piece of legislation was to increase access to finance and overall financial inclusion, in that we wanted to have a more simplified, modern, and unified legal framework as opposed to what we had before. You might not be aware, but before there were fragmented pieces of legislation that govern secure transactions, like the Chattel's Mortgage, Hire Purchase, Pawnbrokers Act, and the main reason for bringing this act into force was obviously one of the main reasons was to just simplify, because there are different rules applying to different financial secure transactions, and this was just to simplify, modernize, unify that framework. We also wanted less complexity by just making these legislative requirements as simple as possible, and in that they are minimal. Like, we will find out later what you need to have a security agreement, how you must establish a security right, just minimal requirements with agreements and registrations. I think the main reason was to reduce the cost of financing. And I don't know before, as most of you either had interacted with a lot of secure transactions, either on the point of the secured creditor or the borrower or grantor, and you found out you had to pay taxes, you had to pay for registrations, all this were factored into acquiring a loan, which became somewhat of a burden and discouraged not only members of the public from asking for loans, but also secured creditors from actually giving these loans. So we wanted to just make it much easier or less expensive to enter into a secure transaction. We also needed more transparency that reduces risks. As I've just mentioned, a lot of secured creditors were very reluctant to enter into secure transactions that involved movable collateral because of the nature of that collateral. They tend to change. Let's say if you have tomatoes can go bad. Yeah, let's say if you had a car, an accident can happen. So a lot of secured creditors are very hesitant to enter into these volatile transactions. And one of the main policies that informed on that was just to make it much more transparent, in that they knew the status of the particular collateral that they had acquired as security. They knew the status, how it was being maintained, and this act sought to cover that, and also to provide just more certainty. What happens in the event that you're using the same collateral over multiple secure transactions? Is my collateral safe? What happens in the event of default? What happens in the event that the format of my collateral has changed? So they just needed that particular certainty when it came to the transactions involving movable collateral. So this act covers all types of lenders and borrowers. So long as you are an individual, it can be a transaction between two individuals, it can be a transaction between an individual and a company, it can be a transaction between two companies, it can be a transaction between a SACCO and a company, it can be a transaction, as it doesn't require a specific kind of person as regards to scope. So long as you're an entity that can be defined by law, you can enter into a transaction under the MPSRA. With regard to property, again, the scope is wide. The only rule with the MPSRA, it covers movables. We do not cover land or buildings. This act, that is under the Land Registration Act and all other acts that deal with a real property. This is for movable property. So long as it's movable, be it tangible or intangible. We are talking about tangible, like a chair, intangible, shares of a company, receivables. These are things that will fall under the scope of this act. The only exception with movables is aircrafts, and that is because of the Cape Town Convention, which governs secure transactions with regard to aircraft or air vessels and ships and all that. So that is the scope of this law. So what this law achieves is a single body of law with regard to secure transactions. It provides for a single register for all security rights with regard to movable collateral. It sets out clear priority rules in the event of default. And also it offers, most importantly, for the secured creditors, efficient enforcement rules, which are both, they could be judicial or extrajudicial. So moving from the scope of the act, now let's get into the nitty-gritties of it. What does this act apply to? It applies to all sorts of transactions. You can, regarding security rights in movables, they can be traditional, which is the simple, I am the borrower, you are the lender, I have a movable collateral that I own, you are willing to take that as security in exchange for the amount of money you're willing to lend me. Traditional security right. It also covers different peculiarities with other types of secure transactions that are not normally in the traditional format. Let's say for retentions of title. We are talking about, I am a wholesaler of water, let's say bottled water. I want to sell to you, Mutuko, who owns a retail shop, ukona duka ya vitu, and you want bottled water. I give you that on credit with the agreement that you pay after 30 days, that is a secure transaction. It's covered under that because I, as the wholesaler, will retain title for those goods up until you pay me. Financial leases, hire purchase agreements. I am the owner. You are the hirer. You want to purchase this eventually. You will pay in installments. That is also a financial transaction, secure transactions that's covered under the Act. Transfer of receivables. You have a book debt. Again, when into a duka, you have several people who have acquired goods from your shop under credit. They are your debtors. You have book debts. You can give those particular debts as security, making it a secure transaction. So the scope of this law is very, very wide. It just gives you room to have endless possibilities on the kinds of transactions you can hold, so long as they are secured and it involves movable collateral. So it also recognizes floating security rights. Again, these are maybe not the ones that they're tangible, like book debts. Future property, we are talking about, let's say, conversion of a particular item into another item. That item didn't exist, but it will convert. Let's say, for example, if you have material, let's say you're a factory that makes cotton material and you want to give that or sell that cotton material to a particular tailor who will convert it into cloth. Does your security rights extinguish from that? No. Just because the material moves from material to cloth, the security right will still exist. Proceeds. You're going to sell off these items. Do they extinguish? The water bottle guy will sell water. The water will be drunk, will be sold to someone who's walking somewhere on the street. Does that right extinguish? No, it transfers to the proceeds. We're talking about future debts, again, with the book debts, yeah? Different types of transactions are covered under this law. So, security right. How do you create a security right? Security right is created. The law definitely describes what a security right is. And basically it falls under what you can see on my slide on security rights. You can just move forward, Rosaline. A security right can only be established under the particular things that are mentioned there. There has to be an agreement. And the agreement has to be a security agreement, not just a buyer-seller. This is borrower-lender, it can be leaser, lessor, it can be hirer, owner, any type of secure transaction, but there must be an existing agreement in place. There has to be parties to that agreement, who is the grantor and the secured creditor. The grantor has to be distinguished from differentiated from the guarantor. We're talking about the grantor. This is the person with the ability to grant that right to the secured creditor. Not necessarily the borrower, he just has to be the one who owns that collateral or has a right to grant that right to the secured creditor. Of course, the most important thing is that there must be collateral, it has to be movable, and then there has to be the secured obligation or the debt. With that, no other formalities are required. Yes, the banks will give you pages and pages, but those are just terms and conditions that they usually put in place to safeguard their interests. But generally, so long as you have those 4 requirements, basically you have formed as an agreement and you've created a security right. Again, with this law, we wanted it to make it inexpensive for both the lender and the borrower, or the secured creditor and the grantor, and we eliminated the need for stamp duty. So a security right will be formed through the agreement, but does this extinguish in various circumstances? Yes, it can be extinguished once the transaction is over. However, there's some circumstances that might come into question, and you're wondering whether the security right is still there or it's not there. And this will come, let's say, in situations where the collateral is commingled with another one. And I'll give an example of maybe like oil in a tank. You are supplying oil to a petrol station on credit. The oil will definitely mix with other oil from in that petrol station. Does it mean that your oil is no longer, because it's no longer distinguishable, you will lose that security right? No, you will not. Processed goods. Again, my example of textile into clothes. You had material, I made a cloth with it. Is my security right extinguished? Definitely not. Deposited into a warehouse. Let's take an example of silos, grains. Many farmers will deposit grains into a warehouse. Will it again be extinguished just because you can't tell whether this grain of rice is different to this grain of rice? Does it belong to Mwangi or Akinyi? No. Again, it will not be extinguished. Access to another asset, tires on a motor vehicle. Will it extinguish that right in that movable asset? Definitely not. So we have already gone through how you establish a security right. Now we are on to how do you effect it? How do you effect it against third parties? How do you make other members out there of the public aware that there is a security right that is existing as against this collateral? Buyer beware, or seller beware, or anyone with an interest with this, separate from mine, beware. How do you make it known and available to everyone? And this is what you call third-party effectiveness. So how you achieve third-party effectiveness is through registration. That is the only means necessary under this law for you to effect your rights against other third parties. So, and how do you register? Which brings me to my next slide, the Collateral Registry. Like I said before, BRS does administer this registry. It is established under the MPSRA. It is an exclusive and accessible registry, which is electronic. All you need to go is online. The registration is immediate. Again, there are no back-end processes. It's just the secured creditor who sits. You make the registration, it automatically uploads, and a notice is issued to you. You can conduct a search on the registry. Of course, there are requirements for you to conduct the search. There is a minimal fee, and that you cannot just conduct a search just like that. Anyone has access to conduct the search, by the way, but you must adhere to the requirements, which is you can search by ID of the grantor, the person who owns the assets and has given it as collateral, or you can search in some cases using the serial number of the collateral. At this point in time, it's just the motor vehicles because they have a more definite serial number through the VIN numbers, but I think there's been a shift with other countries and international law towards making a more accessible registry or serial number collateral in a way that people can actually be able to distinguish the kind of collateral in the event that they wish to carry out a search. Registration is free. The search is at a minimal fee. Amendments are also free. Cancellations are also free. The registry has different functions. Of course, there is a registrar who's in charge of that registry. But what is most important, and if there are any secured creditors in the room or anyone who represents a secured creditor, registration at our registry does not in any way or form verify the legality or accuracy of the information in that registrar. I like to equate our registry with the library. You bring books in a library, we store the books, we avail those books to you as and when you need them. In this case, with our registry, you bring us the notices, we avail the information on the notices to anyone who requires them, as we are not the authors of these notices. So it's upon the registrant to ensure that they make minimal errors or no errors at all, that they're very careful with the information that they actually put in the registry, because you could be held severely liable for it. It could be the wrong information, which would be detrimental to you as a secured creditor, especially where there are multiple security interests over that particular collateral. So all our registry does is to ensure that the mandatory information is provided to whoever has an interest in that collateral when they conduct the search. And that search is again open to everyone. If I want to buy a car, let's say from Raymond over here, and Raymond tells me I will give you a clean title, it's up to me as the buyer to ensure that I go to the registry. It's not necessary, but if you are to exercise due diligence, go to the registry, check whether that particular motor vehicle is encumbered. Yeah, to the registry. So it's very important that the correct information is placed there. A difference in the VIN number can just make a huge difference in even whatever happens. That's how you find goods are sold to third parties and they have no clue just because there was a particular mistake with regard to registration. So the only time the registry can interfere with the registration is on very few instances, as mandated by law, not of our own volition. We will only reject a registration if there's missing information. And again, there's mandatory information that has to be put in. If that mandatory information is missing, we will not accept the application. Or if you fail to pay a fee. With regard to searches attract a fee. If you do not pay for that search, you will not get that information. I hope that is very clear. So once you've registered, all is well and sundry. What happens when there are multiple registrations of security interests over the same collateral? Priority rules. Who has first priority and at what point will they exercise that priority? The general rule with this act is that the first to register has first priority. It is immaterial whether or not you entered into a security agreement with that particular grantor at an earlier date. First to register gets first priority. I hope that is clear. Because of this rule, you will find again that there are multiple interests that can be registered over the same collateral. Please take note of that. As a business, know that this law does allow you, dependent on who you enter into an agreement with, to enter into different security agreements over that particular collateral. Say you have, I'm going to give an example. You're leasing a tractor, you're a lessor, you have tractors that you lease to people. That leasing agreement is a security agreement under this law. That is transaction number one. Let's say as the lessor, you want to borrow from a bank or a financial institution to maybe increase the number of tractors that you have, and you give the particular tractors you have on hand that you're leasing to other people as collateral. Again, a second financial agreement. Two security interests have been established over the same assets. The knowledge of a pre-existing and registered security interest is immaterial. Like I said before, it doesn't matter if you entered into that agreement before. If you didn't register, you lose your priority. It doesn't matter if I, as the second person dealing, give the example again of the leasing. Let's say the lessor entered into an agreement on their tractor with someone else, and that lessor again entered into an agreement with the bank. It will not matter whether the bank knew that this person has already an interest in that particular tractor. If they register first, it will not matter. They still maintain their priority. Of course, these rules again may be altered by parties. You might find that this particular lessor of those tractors will again take a different loan from a different bank. The banks can sit and agree on, in the event that there's default, who gets first priority. I hope we are together. Of course, there are special priority rules. This act is not just there to protect the secured creditor, it can also protect the different parties who at some point will have either acquired an interest, whether it is a security interest or just ownership of the particular collateral. It protects buyers in the ordinary course of business or similar transferees. Take, for example, my water bottle example, which I gave before. You're selling bottled water. I come to your shop and buy the bottled water. Will I be forced to pay for that bottle, for your loan which you took, or the goods you paid in credit, the bottled water you got on credit because I bought the bottle, or will you take it back after I've drunk it? No, that is in the ordinary course of business. The ordinary course of business in this case, you're selling the bottled water. Just because someone else off the street bought it does not in any way detract or separate from that particular security agreement. You cannot claim that as an excuse for the secured creditor to not register or to want to enforce or something of the sort. There are also rules that apply to non-consensual creditors. And in this example, I'm going to give of a judgment creditor. Someone goes to court, sues you, gets judgment, they can't register their interest over your collateral, even though there was no security agreement, because they are an non-consensual creditor in this particular case. Another example is KRA. They can also register against a security interest against your collateral in any event. There's also a liquidator. They can register a security interest of a particular collateral. We're also talking about landlords. They have a right of lien over your property. They're non-consensual creditors. They can register. If they do register, they can have a security interest over that particular collateral. The next, I'm going to talk about effective enforcement mechanisms. As I mentioned before, you can enforce against this particular security agreement, but enforcement will only come in when there is default. A secured creditor cannot enforce if the borrower or the grantor has not defaulted on that particular agreement. So the stages are, there has to be default. Then once there is default, there will be repossession. Once there's repossession, there will be disposal or use of the asset as the secured creditor may do. Of course, there are different proceedings or remedies that you can undertake for enforcement, which include judicial or non-judicial. Judicial is where you have to go to court, get an order to either repossess or sell, or even just be paid for the balance. Non-judicial, you can always go repossess that particular asset. Of course, mechanisms of enforcement can also differ. There are cases where, again, multiple secured creditors. In this case, the superior or the senior creditor will be the one with the first priority. But in some cases, you will find that the junior creditor is the one who may be forced to enforce that particular default, and mostly they will have subrogated that right. The secured creditor may have subrogated that right or transferred that right to the junior secured creditor. Of course, again, rules of enforcement, the grantor has the right to retain or to redeem that particular collateral. That is a right and provided for in law, and the secured creditor must give the opportunity to the grantor in the event that they want to redeem it. The grantor may also waive its right under the agreement, but that is only after default. Matrix of responsibilities. It's important to know who under the law is responsible for what. The registrar is responsible for receiving, storing, and accessing and making accessible to the public information on the registered notices. They also have the responsibility to generate all notices once the registrations or amendments are done. They also generate such certificates, and they remove information in a registered notice only upon the expiry of the period of effectiveness, which is 10 years. The secured creditor also has different responsibilities, and that is to register the notice, any amendment or cancellation. Again, let me make it clear, a grantor will not register any information under this registry. It's only the purview of the secured creditors. They will also register any amendment notices within 6 months before the expiry of the period of effectiveness. They also must, and let me emphasize, because there are a lot of grantors here who will be giving their collateral, the secured creditor must notify you before they make that registration. That is the law, and there are consequences in the event that they don't. For the grantors, they have just one among many duties, the most important being execute those authorizations, and also the duty to just keep that collateral in good care. And with that, I believe I've covered everything on the Movable Property Security Rights Act. If there are any questions, please just put them on the chat, and because in the interest of time, let me proceed with insolvency. If that's okay, Raymond?
Yeah, that's okay. And also to the participants, we note that yeah, our time has run out, so we'll give you like 10 minutes.
Okay, I'll rush very, very quickly.
Okay, thanks.
Insolvency. What is insolvency? I believe this is a very important information, piece of information that is vital for small business owners, because a lot of companies are in financial distress and they are not aware of the options that they have under the law for some sort of relief, or in the event that they think that their businesses are able to recover from the setbacks that they're having. So insolvency arises when an individual or a business is unable to pay their debts as and when they fall due. That's how simple it is. You are supposed to pay, you fail to pay, over a period of time, you are falling on the ambit of insolvency. So insolvency was previously governed by two acts, the Bankruptcy Act and the Companies Act, Cap 46. However, in 2015, there was the new Insolvency Act that was in force, and it was mainly enacted so that we could secure equitable distribution of property belonging to the debtors to the creditors according to their respective rights. It was also to relieve the debtor from liability and enable them to start their lives afresh. It was also supposed to protect the interests of creditors and to punish any debtor who, by illegal means, entered into this insolvency. And by illegal, I say through fraud or misconduct on their part, and to offer a suitable alternative in the event that the debtor feels that bankruptcy or liquidation is not the option for me, I'm able to recover. It was to provide those mechanisms. And if you notice, there was a shift towards debt collection to more towards restructuring mechanisms with the new law. And most importantly, it was just to promote businesses. Investors need to be confident that their structures in the event that a business fails and that they're able to recover the investment that they have given. So what are some of the salient features of this act? The act joined both insolvency processes for the bank, for an individual and for a company. So where they were fragmented from the Bankruptcy Act and the Companies Act, put into one so that you have the Insolvency Act. It regulates insolvency practice and insolvency practitioners. Insolvency practitioners are individuals with that expertise to manage a company or a business that's already in financial distress. There was need for regulation as to how they conduct their business, how much they charge, who they're accountable to, and this is one of the things that this act does. This act introduces instant bankruptcy for an individual. Before, you'd go through different processes before you are declared bankrupt. Now you apply for bankruptcy, you enter straight into bankruptcy. Automatic 3 years, automatic out. You do not need to go back to court to be discharged. Again, different alternatives to bankruptcy with a much bigger focus on restructure rather than liquidation as the end result. With these alternatives, we have voluntary arrangements, we have summary installment orders, and we have the no asset procedure. These are just different procedures. Some court initiated, some you just go to the official receiver. The names will tell you a voluntary arrangement, you enter into an arrangement with your creditors where you pay the amount of money, either a lump sum at one go with a discount or a cut somewhere, or a lump sum at one, or installments for the whole amount or the cut within a specific period of time. A summary installment order, same thing, only this is not court initiated. You go to the official receiver, you come up with a proposal, he puts it before the creditors, gets feedback, and then makes a decision towards it. No asset procedure, again, you should not have an asset when you're applying for this procedure. Initiated at the official receiver, you're forgiven for all your debts with the exception of taxes, child support, spousal support, and it's for a specific amount of money. I think it's less than 500,000 if I'm not wrong. Another feature of the act are joint bankruptcies, where your husband and wife or two partners, you need not apply for different bankruptcy procedures. We do recognize already in financial distress, bankruptcy procedures may be expensive. You can have a joint bankruptcy. Creditors meetings, the range of people who can attend has been extended. If you have relevant information that can help with that particular insolvency proceeding, you're allowed to attend. The list of offenses have been extended, and with good reason. A lot of us as Kenyans tend to be very evasive, tend to be a bit naughty, so we need to increase the number of rules in that you do not fleece off your creditors at some point, and that if you're truly in distress, it's because of obvious reasons that your business failed in some point of way. Of course, there are some entitlements to spouses of either deceased debtors or living debtors that are also provided for. Before, you'd have all the property of the bankrupt taken to offset the creditors, but we do recognize bankrupt people have families. They do have spouses or children who depend on them, and they could retain some of these things in order to at least sustain themselves in the long run. Of course, it also includes allowances made out of the estate of that deceased debtor to surviving spouses and dependents. With liquidation of companies, there are also very important features that are covered under the Act. Again, holding the members or shareholders of a company responsible to a specific extent with regard to the debts that have been accrued by the company, especially when it comes to liquidations. There's also the issue of voiding transfer of shares during a voluntary liquidation or altering the status of members of the company so that you protect the interest of the existing members. Again, limiting the management of these distressed companies to only licensed insolvency practitioners who, as we said before, are experts who are equipped with handling companies that are not in the normal course of business or are struggling or are in financial distress with an aim of either closing down the company or where there is promise restructuring it with the goal of giving it back to the director so that they can proceed to grow their company. Another important feature is Section 474, where an unsecured creditor can get some shares into the assets of a company under liquidation where there is a floating charge on that particular property. So they are allowed to section off a particular amount to pay off unsecured creditors. There is, of course, some at least guarantee that the unsecured creditors will not come out empty-handed. Of course, again, the power for an insolvency practitioner to rescind contracts that of their nature were entered into and they are not particularly beneficial towards this company. Again, giving power to the liquidator to transfer assets to the company's employees, provided the liabilities have been fully satisfied. Again, talking about the kind of documentation that can be given, can be exempted from stamp duty. Again, we're just talking about a company that's not normal, it's in financial distress. And again, offenses that directors might actually have committed that led to the failure or the financial distress of this company. The Act also makes it possible to liquidate unregistered companies. We do also, our office personally, we even liquidate pension schemes, which are not companies. The same rules does apply. We liquidate limited liability partnerships. Again, the range has been increased. Of course, alternatives to liquidation. We are talking about, again, voluntary arrangements where the company comes up with a plan, puts it toward the creditors and the creditors vote on it. We have administrations which are geared more towards restructuring, where an administrator comes through and takes over the company, assesses it and its financial viability and makes a determination on whether they can either go into a voluntary arrangement or if it's not viable, they can proceed to liquidate. Administrative receiverships, these were receiverships that were entered into before the Insolvency Act was enacted, but are still ongoing up and until this point, because the documentation required for receivership to take effect at that particular point in time. Then general rules as to how a company must be or run while in liquidation, such as lodging of documentation with the Register of Companies, procedures where applications can be made either by either party or the official receiver or even the liquidator. Again, different rules, maintenance of public register. An important provision is on cross-border insolvency, where the company has different subsidiaries in different countries, the rules in which can be applied so that a company that's bankrupt in, let's say, Malaysia can make an application to Kenya for recognition and enforcement of bankruptcy with regard to the subsidiary in this country, and most importantly, the priority rules when it comes to the payment of debts. And with that very quick wrap, I am done with my presentation. Thank you for your attention. I'm free to take questions.
Yeah, thank you so much, Beatrice, and thanks so much, Zach. So in the interest of time, we'll be able to briefly just run through the 6 or so questions that have been asked from the chat. Then I'll ask that for the presenters, Beatrice and Zach, to be very, very brief, because also the questions are just very straightforward clarifications. So I'll read through all of them. Then now we can be able to see who is best suited to be able to pick it up. So the first one, I think it's very basic as to, that's Nathan Diego. He indicates that he has been trying to link his business, but the system indicates that it's pending for, it just says pending for review. So what's the concern, and how can it be resolved? The number 2 is a question being asked by Irene Mukure on the integrity and the security issues around eCitizen, because the question is somebody has tried to tamper with his company repeatedly, and also there's a registered company secretary, yet Irene is not aware of that name of the company secretary. And then also he had asked about similar names, but that has been ably answered by Anne Kanage, so thank you, Anne. Then on the issue, slide has been answered by my colleague Roslyn. And then now Samuel Kahura, you indicate that just a concern on small businesses. Do they require the beneficial owners requirement? So I think it's a straightforward clarification that will be provided there by Zach. And then there's an aspect of also this one is straightforward on the returns, company returns and KRA returns. So what do we file on eCitizen? What do we file on iTax? That clarification by Limo Magani. Then on the issue of beneficial owners requirement for companies which are guaranteed ownership limited by guarantee, are they also under this bracket of beneficial owners? And then yes, we've talked about companies, business enterprises, business names, or just the partnerships. Are they required to also be able to comply with the requirement for business ownership? That's a question from Margaret Amimo and Esther Muni. They've asked the same question. Yes, then we end there on the questions that have been asked at on the chat. So if you can be able to run through very fast in the interest of time, because we really value our participants' time, then we'll really appreciate. Thanks so much.
I think, Zachary, maybe you can take these ones. I am available to support in case they need further clarification.
Oh, okay. I think I've gotten 4 questions. I don't know whether at some point there were other questions which were raised. The first question is on whether small businesses are required to file their BO. Now, when you talk about small businesses, they could be in any nature. So let me just divide the different kind of registrations that may be could be distinguished. We have the business names, which are registered as BNs, that is the sole proprietors. Those ones are not required to file their BO. We have partnerships. These ones still are not required to file their BO as at now. We also have a different category of partnerships, that is limited liability partnerships. These ones are similar to or closely related to companies, but they're not companies per se. These ones in the near future, probably they'll be required to file for BO because they are identified as legal entities. But as at now, they will not be required to file for the BO. Now, in terms of whether companies limited by guarantee are required to file for their BO, at the moment, we only have an e-register for BO for companies limited by shares, private companies limited by shares at the moment, such that any other company that will be maybe intending to file their BO at the moment, they'll not be in a position to, until we announce that these companies will be required to file at a particular time. So for companies limited by guarantee, in the near future, they'll be required to file for their BO, and the threshold will be the voting rights because they do not have shares. But at the moment, only private limited companies are required to file for their BO because that is the only register that is available. Then lastly, on company returns, we have annual returns and then we have KRA returns. For KRA returns, you file on the iTax. For company returns, you file on the business platform, that is the eCitizen platform. So thank you.
Thank you. Just maybe to add, I think there was a linking issue which I was going through the charts and I believe was sorted. However, it's just important to point out if you can, and you have a business that was enacted prior to us going digital, it's very important that you initiate your linking process as soon as possible. You will find that in the event that you're required to do something quite urgent, like there's a deadline for BO, you'll find that everyone was now rushing to file their BO, then finding out they had not linked. And that again clogged the system, and because companies registry operates also from the back end where they have to verify the information. It's very important that you do not clog it to a point where they are unable to now speedily resolve your whatever issues you have or speedily go through your BO registration requirements. So we do encourage all our customers that it's important that you start your linking early, so that in the event that you may require, you have a job, you require your CR12 as soon as possible, you're not again struggling with getting people to link your company because you're unable to get your CR12. So with some of these processes, as soon as you start them as soon as you possibly can, so that you're able to retain these services or access these services as quickly as possible. Yeah, I hope that is also clear. Also to add on to, there's something about business names and partnerships, and yeah, once you realize the kind of business you have, you will again find out the kind of rights or responsibilities accruing to it, and then you're able to, whichever issue that comes up can be resolved amicably. I think that's the extent of my contribution. So unless there are any other questions, I'm assuming there's none on insolvency or MPSR because no one has asked, but you are very available in the event there are any questions. You can go to our website. It has all our contact details where you will be able to find all of us in the event that you require further assistance. You can also visit Sharia House, although with COVID-19, we are trying to limit visitation. So do visit our website and make use of the numbers or the emails that are available there from. Thank you.
Yeah, thank you so much, Beatrice, and thank you so much, Zachary. Yeah, in the interest of time,
excuse me, is it possible to ask one last question?
Yes, you had raised your question earlier, so I'll only allow you just one.
Yes, I actually hadn't asked any question. I just raised my hand, but it's a very quick one, and I was hoping Zachary could probably assist with this on the beneficial ownership. I remember at the beginning of the discussion, he mentioned that the reason for this is to unmask the people behind, for to unmask the people behind the companies, and if they are hidden, or for purposes of anti-money laundering and prevention of terrorism. My concern right now is that as the system is currently configured, there is no point at which one is actually asked to identify the ultimate beneficial owner. Like the system does not allow you to. You just tell you're only saying direct or indirect and the percentages of the influence, but you're not being told, how do I disclose the ultimate beneficial owner? So is there anything which is being done? Because right now, I think, in my opinion, we are breaking the law while complying with the law. Is there anything which is being done to at least improve the system so that we can disclose properly where people actually want to comply? Thank you.
Thank you, Mutegi. I think we are continually working to improve the system, but you can actually add a beneficial owner in case that the person is not listed in the list of shareholders. There is an option to add if someone is a beneficial owner. But as I've said, we are continually improving the system. Maybe in the near future, it'll be required to maybe you'll have more options in terms of what you can do. Thank you.
Yeah, thank you so much to all of you, and just an appreciation for stayed tuned for all this period, and also to Beatrice and Zachary. That has been very, very enlightening, and now we are aware as to where we can be able to channel our concerns, and also just to be able to get more empowerment for our businesses, our enterprises, to ensure that yes, we comply, and we can also be able to make the steps to move forward. And also when we get into challenges, like for the insolvency bit, it's well explained, because it's an area that many of us have limited understanding. So we get into it, and then now you're very limited. You have very limited options as to the information, and also the right process to be able to follow. So thank you so much. And that we have indicated on the chat, we'll be able to share the slides so that we can be able to remind ourselves. And as it is able to say, yes, this is not the last of it. Feel free to be able to interact with the website, and also feel free to be able to make contact with the BRS for further and more greater and finer details, and very, very specific to your need as a business. So thank you so much, and we look forward to connecting with you once again on the next empowerment session. Thank you.